The Trump administration is asking the Supreme Court to get involved in the legal fight over its use of the Alien Enemies Act to remove alleged Venezuelan gang members from the country. This comes after U.S. District Judge James Boasberg temporarily blocked the use of that act, and then a D.C. Circuit Court of Appeals panel agreed to keep his order in place. On social media yesterday, Trump went after Judge Boasberg again, writing in part, if it was up to District Judge Boasberg and the other radical left judges, nobody would be removed. The president wouldn't be allowed to do his job, and the people's lives would be devastated all throughout our country. Trump also reposted a call from a conservative attorney to revoke Judge Boasberg's security clearance, which would have big implications. Joining us now to talk through some of those, former assistant district attorney in Manhattan, Catherine Christian. She's an NBC News legal analyst. So let's start there, Catherine. President Trump reposting that call to revoke the security clearance of Judge Boasberg. Can he do that? And what would the impact of that be on the judge being able to continue in his position without a clearance?
Well, federal judges are not required to have security clearances by the dint of their office. And yes, the executive has wide discretion over who gets a security clearance or not. This might just be more blather. I think the administration has talked about revoking security clearances from people who don't even have them. So it would be problematic if this judge was presiding over a case with classified information and in some way the administration swept in and said that he will not be able to review that classified information. Clearly, that would be a problem for the defendant who is on trial. But federal judges generally are not required to have security clearances.
But we've seen in the Alien Enemies Act case the way that the administration has tried to say that they can't talk about certain details of this because of national security concerns. And so getting rid of his clearance might cut to the heart of that argument. But when you look at the way that the administration, allies of Trump, and of course Capitol Hill has reacted to Boasberg and other judges halting or pausing actions from the administration, they've talked about revoking security clearances, but they've also talked about impeachment or defunding some of these various branches of the judiciary. What does that all do when it comes to the credibility of the third branch of government here? Well,
the problem is because the public is hearing this. And we're talking about, chilling the independence of the judiciary. You would hope that judges will sort of block all of that noise out and just do their job. But it's very hard. It's also, quite frankly, dangerous because most federal judges, Supreme Court justices have 24-hour security, but most federal judges do not. They just go about and do their job. So there are people who hear, these basically threats of impeachment, and they may take actions that could be dangerous to the judges. So it is very disheartening as a lawyer who appears before judges to hear, the other branch of government, the executive, attacking judges they don't like. If you don't like a decision, you appeal it. You don't publicly excoriate a judge. And we've certainly seen that kind of violence as well against judges and their families in recent years. But you talk about the chilling effect here, Catherine, and the president has continued to go after law firms that represent clients he doesn't like.
And now to this one. Two more law firms have now filed a suit against President Trump, while another is striking a deal. On Friday, two federal judges who were both appointed by Republican President George W. Bush partially blocked the executive orders against the firms Jenner and Block and Wilmer Hale. The president sought to penalize those firms for taking up cases that go against his agenda and employing attorneys who worked on criminal investigations into Trump. The judges called the orders troubling and retaliatory. Perkins Coie was the first firm to sue the administration earlier this month. A judge temporarily blocked that order, calling the president's actions chilling. Meanwhile, the firm Paul Weiss took a different path, having its order dropped after agreeing to provide $40 million worth of legal services for the White House. Another firm, Skadden, followed suit last week, striking a deal with the White House in order to avoid an executive order. The White House announced that agreement on Friday, in which the firm will provide $100 million in pro bono legal services for the Trump administration. Ken Delanian, what is your latest reporting on this story? And I wouldn't mind hearing some analysis as well.
Yeah, Mika, this may be one of those things that isn't breaking through because we're talking about big law. We're talking about law partners that make millions of dollars a year, not exactly the things that regular Americans care about. But this is an enormous thing that's happening in the legal profession and in the justice world. And it is really roiling the people that I'm talking to. They're very concerned about it because they say that these orders, these executive orders that Donald Trump are issuing are patently illegal, discriminatory, unconstitutional. 2 judges, as you said on Friday, have essentially ruled that way. And yet of the 5 law firms that have been targeted, as you said, 2 have settled. 2 have decided to pay some money and do some pro bono work that Donald Trump wants them to do and to make statements about DEI and other things. And that has sparked resignations at both firms because people view that as capitulating to Donald Trump. And as you said, the reason he's doing this is, in the case of WilmerHale, for example, one of the firms that is suing, it's because that was Robert Mueller's old firm, and one of his top aides, Aaron Zebley, is a partner there. So, look, this is the kind of thing we're seeing with this administration. They are pushing as far as they can, and whether they get slapped back by the federal courts is almost immaterial because the message that's sent is unmistakable. It's chilling law firms across the United States. And in fact, what these orders would do to these firms is essentially they would take security clearances away from some of the top lawyers. It would bar them from federal buildings. So they represent some of the major federal contractors who are calling them up and saying, wait a second, I don't know if we can continue with you because we don't know if we can bring you into a federal building.
This man does not plan to leave this White House. All of this is about suspending, if not eliminating, the Constitution of the United States. And that's the track we're on. And I think people better get serious about this. When he says he's not joking about throwing away the Constitution, which is what he'll have to do in order to have a 3rd term, and we are not going to rise up in opposition to that, I think it's time for us all to wake up.
We're joined now by CNN senior legal analyst Ellie Honig. And Ellie, the 22nd Amendment is very clear. No person shall be elected to the office of the president more than twice. Where is this wiggle room that Trump is seeing?
Well, Bree, you're exactly right. Lawyers love wiggle room and escape hatches, and here they're looking at the word elected. So here's the argument. It's fringy, but the 22nd Amendment says nobody should be elected president more than twice. Well, the theory is, well, then maybe what Donald Trump or any 2-term president can do is run as vice president with, let's say, J.D. Vance at the top of the ticket. If they win, J.D. Vance resigns, Donald Trump becomes president. The argument is that, well, that wouldn't be getting elected. That would be becoming president through the line of succession, ascending to the presidency. So now the biggest problem with this, of course, though, is earlier in the Constitution. The 12th Amendment tells us that any person who's ineligible to be president is also ineligible to be vice president. So you would think that ends the question. That seems pretty straightforward. There is a very fringy, extreme school of thought that the 12th Amendment doesn't quite close the door on this, but I think those advocates are trying to thread a needle that is not threadable.
A little too cute by half there. So Trump said in addition to the J.D. Vance option, there are others too. That's a quote. What are they?
Well, the most straightforward option, it's completely unrealistic, but we can always amend the Constitution. I mean, we have done that 27 times in our history. It's virtually impossible in today's political landscape. In order to amend the Constitution, there's 2 ways to do it. One, we can convene a series of statewide constitutional conventions. That's never happened. That's not going to happen. 2, maybe equally as unlikely, you would have to get a 2/3 vote in the House of Representatives, a 2/3 vote in the U.S. Senate, and then 3/4 of the states, 38 of the 50 states, would have to ratify that. So in theory, you could do that, but there's a 0.00% chance of that happening in reality.
And I mean, just talk about why this is an important tradition that has been codified in the Constitution. This is something that makes America quite extraordinary.
Well, and that's exactly why I think these end runs, playing with the word elected or trying to argue the 12th Amendment doesn't apply somehow, that's why I think they're disingenuous and dangerous. Part of what we have to do when we look at the Constitution is look at the spirit, look at the intent. I mean, George Washington stepped down after 2 terms because he understood we don't want a king. The reason we ratified the 22nd Amendment in 1951 after FDR had served 4 consecutive terms is we didn't want that. So you're right. I think norms are really important here, and that's part of what's different. Look, Bill Clinton and Barack Obama both served 2 terms. Neither of them, and so did George W. Bush, none of them ever in any serious way spoke about, considered, gave any life to the possibility of a 3rd term. And Donald Trump's doing it differently.
So you have a Republican Congressman, Andy Ogles, who has proposed changes to the 22nd Amendment. He did that just days after Trump took office back in January to allow Trump to serve a 3rd term, drawing a distinction between consecutive terms and non-consecutive terms. What do you think about that?
That's what we would call a distinction without a difference. I mean, who cares? The point is, we don't want kings in this country. It doesn't matter if they take a few years off in between. But look, God bless. I mean, if he wants to propose a constitutional amendment, if he can get 2/3 of the House, 2/3 of the Senate, and 3/4 of the states, then that'll become the way we do business. But I think he's looking for some way to argue that this situation is somehow different than the rest of our history, and it doesn't fly to me.
All right. Ellie Honig, thank you so much for taking us through the legal ins and outs of that.
All right.
Still ahead tomorrow, we may see how voters are responding to President Trump's 2nd term agenda. We'll take a look at special.
Trump is threatening the judge. He's threatening the judge's career. He's threatening their ability to do it. Now, we should be clear that judges don't require security clearance to work as a federal judge. It's not necessarily a requirement of the job. But there's a couple things. One, Trump doesn't necessarily know that. Trump is dumb enough to think that maybe you do require it. And as a result, by him removing it, it's a way of firing the judge. Now, Trump might be told by an advisor, sir, it doesn't work like that, but that might be Trump's intent. But it's also weakening this judge's ability to do their job. And a good judge might say, well, if I don't have security clearance and I can't view certain classified documents, how can I be the best judge I can be? One of the benefits of a judge having security clearance is if there is a case around classified documents or, classified information that a person might need to testify on. Maybe you have to, have the jury, all of this. You have everybody sworn to secrecy. There's extra provisions that a judge that has security clearance can actually do that. But if a judge doesn't have it, it limits it. But the point with all of this is Trump threatening the legal apparatus, threatening judges, threatening law firms, threatening the Constitution itself, because he views himself as an emperor above the peasants being the American people, but in particular, non-wealthy American people. He sees himself as better than you, not just in the classic I have more money than you, but in the very, very, anti-American sense where it's like, no, I am literally better than you. Like, I am above the law. Me and my lords, me and my dukes, my earls, my counts, my princes, if you will, very medieval European, me and my Prince Musk and my Duke J.D. Vance and all my Republican counts in the House of, all of this, right? It's very much like we are up here and you are down here. And you peasants better get used to it. And the law does not apply to me. It does apply to you, but it does not apply to me. This is the Republican motto. The law exists to punish Republican enemies and protect Republicans from the consequences of the law.